You ready?
Yes.
Okay. All right. So you're on the record, yeah?
Yes.
Okay. Now we're here for various criminal motions. State, please announce your presence.
Nicole Santini on behalf of the state.
Good morning.
And Ms. Creamy is also here with me.
Very well. Good morning. All right. The first case I'm going to address is 20 MM 294, State of Florida versus Regis Edward Andrus. Mr. Andrus, can you hear me?
Hello.
Mr. Andrus, can you hear me?
Yes, I can hear you.
All right.
I'm a little hard of hearing, Your Honor. I'm 85 years old, so I
Yes,
don't
sir.
know if you remember me at all.
I do remember you. I'll do my best to speak up, you know, but I'm soft-spoken and I'm wearing a mask, so I'll do my best.
Okay.
All right, sir, this is your motion for termination of probation. My question is, the one condition that was at issue was turning over your saltwater products license.
Right.
Have you done that?
When I went down to the probation office, the girl had me fill out a paper, and I filled it out, and I had to wait about an hour. Then a man come over, and I thought it was a probation officer. I tried to give my license to the girl, and she said, give it to the probation officer and tell him. Well, I did that with the man that came there, and he had me make me sign the paper. He said, here, you have to sign this. I signed it, and I said, well, what about my saltwater products license? And he just walked away.
All right.
And he never said a word, never come back. And I asked the girl, and she says, I don't know. He handed me a card, and it had the probation officer's name on it. So he was not my probation officer. And I called the probation officer whenever I got home and asked him about it. And I said, I talked to you in there. He said, you didn't talk to me. I said, well, the man was very ignorant to me and handed me a card and walked away from me. And I tried calling him back, and he wouldn't talk to me. So I still have my card, but I'll give you that. But I'm not a commercial fisherman, Your Honor. I have 5 crab traps, and when they were on my boat, they took 3 of my traps.
Sir.
And they never did return, but they're worth like $50 a piece. But I just have recreational crab traps. My license is from years ago when I used to do netting, 25 years, 30 years ago. And I just send $50 in and keep it up all the time. That's all.
All right. No, I understand.
I'll send you my license if that's what you want. I don't do a commercial now. I just have 5 traps out there for my own crab trap eating. That's all.
Sir, it's not what I want. It's what the plea deal was. And the plea deal was you can terminate your probation upon surrender of the license. So I just need to know if you had done that already. So
no, I haven't done it. I tried to give it to the guy that I thought was probation officer. He wouldn't have it. I still have it. I can mail it in with a check for what my fine is and that.
All right.
However you want to handle it.
Let me ask, I have an officer from probation present. Let me ask her if there's anything left outstanding that he needs to do other than that.
Good morning, Judge.
Good morning.
Yes,
Which is how much? All right, sir, here's the deal. I'm going to sign an order today saying that your probation shall terminate upon surrender of the saltwater products license and payment of the $75 probation fee. You can
let me have you talk to my wife and let her write this down.
Okay.
Your Honor?
Yes?
The plea offer was to surrender it to FWC.
Well, there. Hello, ma'am. Ma'am, can you hear me?
Yes.
This is Judge Brown. Hold on 1 second. I want to hear from the state attorney.
Sure.
So the plea term was to surrender it to FWC. I understand based on the court notes or on the judgment and sentence, it stated that he was to surrender it to probation. So I know that was the court's interpretation. I just wanted to make note of that.
Okay. Well, I'm looking at the judgment sentence. The judgment sentence, it doesn't specify who he has to surrender it to. So as far as I'm concerned, if he surrenders it to probation, that is sufficient. So, ma'am, can you hear me?
Yes.
Ma'am, if you and your husband can simply mail the last supervision check, which is $75.
Okay.
And fishing license to probation, your husband's probation will terminate. I'm going to sign over today granting that. So as soon as that's received by probation, your husband is done with probation.
Okay, $75 in his license.
The fishing license, not driver's license.
Yeah.
Right?
Yeah, the SPL one.
Correct. So, yes, I need to hear one more thing from probation. Go ahead.
Now, let me ask you something. I'm looking at the judgment.
All right. Well, here's the other thing. I was listening to the judgment and sentence, was listening to the actual sentencing on CourtSmart, and it wasn't clear upon whether it was may or shall. Everyone kept saying can. I don't know why I said that. But as far as I'm concerned, upon surrender of the license, probation shall terminate. I'm going to issue an order accordingly. So, who do they need to mail the license to? Who do they address it to? To Danny Hornbeck? All right, ma'am. So you need to put it in an envelope, send it to county probation, care of Danny Hornbeck.
Okay.
Who's Mr. Andrus's probation officer.
All right.
And then that'll be it.
Okay.
All right.
It's just the $75 and then his license. Send that in. That's it.
And he'll be done with probation. I'm being told there is still outstanding court costs. Now those will still have to be paid, but that's not part of probation.
Oh, okay. Okay. And will we get those in the mail or?
Yes, you can send it. You can send it by mail.
Okay. I mean the other part that you're saying.
Which part? The court costs?
Yeah.
Yes, you can pay that by mail as well. You can send a check to probation. Can they do it probation, or they have to do it to the clerk's office? Do you have access to the internet? Are you able to get online?
Yes.
You can pay online at callyourclerk.com.
Callyourclerk.com. Okay.
All right. Any questions for me, ma'am?
No. Any questions, Rich? Do you have? Yeah. Okay. We understand everything. Thank you so much. We appreciate it.
All right. Good luck to you folks. Take care.
All right. Thank you so much.
Bye-bye. For the record, those folks are in their late 80s and they live in everybody's city. I just don't want to make it too complicated. All right. All right, I do have some folks here who are for a plea. Let's see. Mr. Hines, good morning.
Good morning, Judge.
This is State of Florida versus Daryl Thomas Edwards, 19 MM 950.
Yes, Your Honor. We have a negotiated plea in this case.
Okay.
Come forward, sir. Judge, would you like them to warn about you at the podium?
Yes, please.
Okay. Go for this issue. Okay, here's what happens. I have to speak up if my phone is not on.
It's not?
No, sufficient for the
Oh, okay.
Judge,
Yes, sir.
in this case, what we agreed with the state is that the state is going to, I'm not sure if they're going to amend the charge to charge reckless operation of a vessel, or if that would be a lesser included offense to charge defense operating under the influence. The reckless operation statute is 322.33 sub 1.
Okay, is that correct, State? Are you amending the charge at this time?
Yes, Your Honor. The offer was to amend to a reckless operation of the vessel.
All right.
Judge, I believe the agreed upon disposition of the case was that he be placed on 6 months of probation, pay a fine of $250, plus the statutory court costs, plus prosecution, and attend on the state voting safety course.
So you agree that those were the terms?
And also that he may early terminate at 3 months.
Yeah, and he's right, and he's already termed, he completes everything.
All right. Mr. Edwards, Mr. Edwards, do you want to accept those terms as part of the, do you want to accept that plea agreement?
Yes, sir.
Very well. Please raise your right hand.
Do you promise to affirm the evidence you share there shall be the truth, the whole truth?
All right, you put your hand down, please. State attorney's going to ask you a few questions. Go ahead, please.
So right now in 19 MM 950, the state announces an amendment to the charge to be a reckless operation of vessel, according to Florida statute 327.33.
327?
It is, right, the other one, right?
Okay. All right, and Mr. Hines, you're waiving formal filing and arraignment?
Yes,
Very well.
Sir, can you please state your full name?
So I'm going to need to ask you to speak up, okay?
Daryl,
Thank you.
And what's your date of birth?
8/15/81.
And you have been charged with a reckless operation of a vessel. And as to that charge, do you understand the maximum is a year in jail?
The reckless operation of a vessel, the first degree misdemeanor?
It is the first agreement.
Okay.
Does he understand that?
Understand the maximum penalty is 1 year.
You said yes.
Sorry, I couldn't hear. And to that charge, how do you wish to plead? Guilty, not guilty, or no contest?
No contest.
And did you understand the terms of the plea agreement?
Yes.
Have you read and signed a copy of the plea form?
Yes.
And do you understand all the rights listed on that form that you will be giving up by entering this plea today?
Yes.
And are you entering into this plea because you believe it's in your own best interests?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Are you taking any medication?
No.
Do you suffer from any mental illnesses?
No.
Have you discussed the terms of this plea agreement and the rights you're giving up with your attorney?
Yes.
Are you satisfied with your attorney's advice?
Yes.
And do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of your plea?
Yes.
And do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
And do you need any additional time to discuss any of this with counsel?
No.
And do you understand that a reckless operation of a vessel is an enhanceable crime, meaning that if you commit this crime again in the future, you could receive more jail or prison time, a higher fine, and or a longer driver's license revocation period?
Yes.
And Your Honor, the state tenders the plea.
I reviewed the probable cause affidavit. I do find that there is a sufficient factual basis and venue. I've considered the colloquy and find the plea to be freely, knowingly, and voluntarily entered. Therefore, I will accept the plea and impose sentence as follows.
Adjudication or withhold, right here.
State with a withhold or an adjudication.
Adjudication.
Yes, that's very good.
Adjudication.
Yep. To the amended charge of reckless operation of the vessel, adjudication of guilt, $220 in court costs, $250 fine, $50 public defender application fee, $50 cost of prosecution, 6 months probation. Special conditions of probation are as follows. You must attend a motor safety course. And that was it? There were no other conditions?
No, there are.
And that the probation may terminate at 3 months.
Right, but no other conditions.
Right, Your Honor.
Okay, and you may petition the court for early termination upon successful completion of all conditions and having served at least 3 months. Okay, good luck to you, sir. She's currently CLI. No, you have her name correct.
I'm sorry.
The name's correct.
No, I'm told people we can't enter the motion.
Oh. It was like you were hiding behind them. Okay. All right. I've got one Jose Soria, 20 CT 2469.
You know what we have?
All right.
He has reached the period of time form to be prosecuted with martial. And I can just see attorney, please hear me okay, as, from where I am.
Probably not.
If you would.
If you
would it
could
be easier
come over there.
Terms on the record, is that easier?
Yes. It might be easier, Ms. Woodley, if you came around and went to council table. All right, so would you please put the terms on the record?
For case number 20 CT 2469. What? Does he need an interpreter?
No.
Oh, okay, sorry.
Wait.
Count
Fine, yes? Okay.
Count 1 for a DUI second is adjudication, $1,000 fine, 12 months probation, no early terminate, 12 months of driver's license suspension, substance abuse evaluation, follow recommendations, random testing, no alcohol, victim impact panel, DUI school, 10 days impoundment of all vehicles, 1 year of ignition interlock in all costs. Count 2, driving with a suspended license, adjudication, time served, all costs. Count 3, refusal, adjudication, $250 fine, concurrent to count 1. And then 6 months probation, no early terminate, and all costs. And that probation is concurrent to count 1. And did you want me to tell the other case offer?
Hold on, is there another case? I don't have another case. Are you aware of something that nobody else is?
Oh, he already pled to that case, never mind.
Okay. So this is just this today. All right. All right. So, Ms. Woodley, you were able to hear the state. Do you agree that those were the terms of the plea agreement?
The only thing I asked is, there's no objection if you do the federal partial placement.
That's fine.
I wanted to ask too, when you get rid of information. I only supposed to be there, I gotta think of this, minutes forward, so that's how I got the DUI.
The only issue was that they were wondering if you would consider last minute amending it so he does exceed everything.
And the other thing is, I have to throw my calls for this stuff, so I ask for someday to do
Well, that part will address. We don't do that now because you may buy another car at some point during the term of probation. All right. The defense has a request. The state, if they're willing to allow him to petition for early termination upon successful completion of conditions.
No, Your Honor, that's not a part of the plea offer, and we won't agree to that now.
It's not part of the plea offer. State's rejecting that counter proposal. Does that change your position? Are you still willing to go forward with the plea at this time? Do you need a moment to talk to your lawyer? Ms. Woodley? Do you need a moment to talk to this gentleman? I can give you a minute and call another case. Ms. Woodley, I have several other attorneys waiting. Why don't you talk to your client for a moment and they call a couple other cases? It's okay, sir. I want you to make an informed decision, having a good conversation with your lawyer. Talk to your lawyer. I'll be right back with you.
Judge, this is Ms. Karimi. While they're taking a moment to speak to each other, I think this plea also may result in a habitualization, so that might be something Ms. Woodley wants to discuss with him.
Well, okay. I would have thought that that's something that would have already been addressed. Okay. Mr. Ruddy? This is 20 CT 44. Good morning, sir. Good to see you again, sir. All right. Mr. Ruddy, where are we at? Have you either done the recommended counseling or obtained something in writing from the provider indicating that you are not required to do any more counseling.
This sort of that Q&A honor, we had a discussion that we want to follow through with the recommendations that you put forth earlier in our court hearing.
He actually completed.
I completed the DUI school, phase one. I completed the Florida Southwest Safety Council.
I should verify that because the last time we were meeting,
I do have those certificates. I then completed the I Drive Safely course required from Tallahassee. And I have paid all fines up to date, so I have zero balance. And I have stayed on top of monthly probation fees and required check-in on the first of the month. So I completed the layout of what the court had provided me to do so.
There was only one thing that you had to get done, and that was to get some sort of proof that counseling was either completed or otherwise not necessary.
I do have that, Your Honor.
Very good. Has that been turned over to probation?
Yes, Your Honor, all conditions are.
Very good. I don't need to see anything else, sir. State, would you like to be heard at this time? I've been informed by probation, all conditions have been completed.
So the state has no objection then.
Probation, would you like to be heard any further?
No, Your Honor.
Ms. Ruddy, your motion to terminate has been granted.
Thank you, Your Honor.
All right. I'll do an order the moment I get off the bench. All right.
Okay, thank you very much, Your Honor.
You're free to go, sir. Take care. All
I
right.
checked in with probation. Is that probation on the line right now?
No, they're right there.
Okay. I haven't met you before.
They've got a lot of officers.
Okay, do you need anything from me?
No, Your Honor.
All right. You're free to go, sir. Your probation is terminated. Have a good day.
Thank you.
Yes, sir. Sure. Nope. Take your time. Take your time. Just let me know when you're ready, okay? For the council who's been waiting patiently on Zoom, I do appreciate it. It's just that you try to get the folks who are in the courtroom moving as quickly as possible.
Is there any other clue?
I don't know. There's no more, please.
Yes, there's one more.
Oh, right, Ms. Woodley's case. Thank you, Aaron. But I'm gonna go ahead and address the attorneys who are on Zoom as soon as you're ready.
Okay, then let's just move on now. Before that, please, I'll try to get.
I'll take care of these four folks first. All right, Ms. Roger?
Good morning, Your Honor.
Good morning, ma'am. Thank you for your patience.
Oh, no problem, Your Honor. The only case I have with you this morning, Judge, is Brandon Poutine. It's a motion to return property.
Yes, ma'am.
He had surrendered his firearms as a condition of his bond. He has successfully completed the diversion program and his criminal charge has been dismissed by the state attorney's office. So we're just seeking the return of those firearms at this time.
All right, this is 20 MM 106. State any objection to the motion?
We just want to make sure that CCSO was on notice about the request. And
They were, Your Honor. I did receive the state's email. I had sent CCSO a copy of the motion, the notice of hearing, and the property receipt and the inventory.
Okay.
And did they have any objection to the request?
They didn't respond.
Well, the state has no objection then.
All right, motion is granted. I have a proposed order that you sent. I'm getting it now.
Yes, Your Honor. Thank you. That's all I have.
Thank you, ma'am. Take care.
You too. Thanks.
All right. I've got Mr. Gorman. Morning.
Morning, Your Honor. We've got two cases on today's docket. First one is Genevieve Granholm. This is 28 MM 864. This is defense's motion to expunge. Ms. Granholm is eligible. We filed the original certificate and have paid the $42 to the clerk of court. At this time, we'd be moving to expunge.
No objection from the state.
No objection.
All right, I'm reviewing the file now. There is a motion to expunge. There's a supporting affidavit. There's a certificate of eligibility for expungement that has been filed with the court, and $42 has been paid. The motion is granted. You can just send me a proposed order, please.
Yes, Judge, we'll send that right away. Next judge that we have is William Horvat, 20 MM 100. This is defense's motion for early termination of probation. Mr. Horvat has completed all outstanding terms and conditions. At this time, we be moving to early terminate.
State, any objection?
I believe that probation said his conditions were complete, so we would have no objection.
All right, would probation like to be heard? All right, probation has no objection either? All right. This was a battery charge. Was the victim contacted, and did the victim wish to have any input on the matter?
For Mr. Horvat, it was a criminal mischief. That's what?
The battery was null, regardless. Sorry, the battery was no problem. But the criminal mischief, nonetheless, still there's a victim.
Sorry, I didn't. One moment, Your Honor, I'm sorry.
No problem.
So that was contemplated in the plea agreement, and which the victim understood.
All right. Respectfully, I disagree that satisfies the constitutional rights of the victim. They have a right to be consulted when it's a may terminate. If the state has the option of objecting, then the victim has the right to be heard. But, I mean, this was a 6-month probation. The judgment sentence was 3 months ago. The motion is granted.
Judge, we'll send the order in chambers.
All right, thank you.
Have a good day.
Mr. Hyder?
Hey, good morning, Your Honor.
Morning, sir.
Your Honor, I have Mr. Friar James Mendez. It's 20 CT 1510, and we're here for a plea in absentia, Your Honor.
All right.
Your Honor, you should see the complete packet entered. Page 2 of our plea in absentia, paragraph 15, contain the terms of the plea. This is a no contest plea to the charge of no valid driver's license. The terms are an adjudication of guilt, $100 fine, court costs, and cost of prosecution. That document's completely executed, signed, notarized. There's a complete set of prints done by a Lee County deputy. And then we also included a misdemeanor plea form in his native language of Spanish.
All right. And counsel from your office went over the plea in absentia in Spanish with the defendant?
Absolutely, Your Honor. My partner is fluent in Spanish. I'm getting pretty good myself.
Fair enough. All right. State, have you reviewed the plea in absentia? Do you have any objection?
The PIA is accurate and no objection.
Let's see. It's an adjudication of guilt, $100 fine, and cost. Is that correct?
That's correct, Your Honor.
All right. I have reviewed the citation as well as the driving record and find that there's a sufficient factual basis in venue. I've reviewed the plea in absentia, and as indicated by counsel, there's a complete recitation of the terms with the rights being waived by the defendant. The plea in absentia is signed by the defendant and sworn to before a notary. There's an attached set of legible prints as well as a signed plea form. Therefore, I do find the plea has been freely, knowingly, and voluntarily entered.
Because it's part of, you'll mess up the one printed out, so.
What's that?
There's nothing to approve because I haven't done yet because I'm having issues with the plea.
Oh.
So remember I told you I had to contact, try to fix it before.
Oh, because the computer's not working properly.
Yeah, so.
All right.
I'll have you approve it.
So I will impose sentence as soon as the computer lets me.
Your Honor, I need to amend the charge first anyway.
Okay. I thought that would be done because it was originally a DWS. They're amending it to no valid.
Yes, Your Honor.
Okay. All right,
So-
go to that.
Do you want me to wait, Your Honor?
No, so you're amending to 322.01. No valid deal. Is it 01 or 03? 03. 322.03, subsection 1. Thank you.
And we included that in our plain absentia as well in paragraph 1. That's for the record.
They had to formally do it, which they just did.
Correct, Your Honor. Well,
Which we will enter into the computer along with the imposition of sentence as soon as the computer lets me do it. Mr. Hyder, you're welcome to hang around for a few minutes until we get the computer on board with our plan of.
Sure. Yeah, I don't have anywhere else to be, so I'm happy to hang out.
All right, so, or you can just trust me that I will do it as soon as the computer lets me.
I also trust you to do it correctly. So, either way, court's preference.
All right. He's partners with Mr. Rios, but the spelling of your last name, sir, is Heider.
That's correct, Your Honor.
First name Matthew.
And Your Honor, if I may interject, just for the record, Ms. Santini, I know that you were about to amend. Did you actually amend the charge?
Not yet. I was waiting to.
Okay.
I didn't know if we were waiting on the computer or if I can go ahead and do that, Your Honor.
Go ahead, make it so.
Okay. So let me go back to the case. So in case number 20 CT 1510, the state amends the charge to driving without a valid license according to Florida statute 322.03.
No official.
And that's a second-degree misdemeanor, correct?
That is correct.
Yeah. All right. So thank you for your patience with us and our technological issues. We will resolve this in just a few minutes.
That sounds great. I'm going to go ahead and sign off, Your Honor. I hope everyone has a great day.
Thank you, sir. Take care.
You too.
All right, Mr. Hopkins, thank you for your patience, sir.
Yes, sir. Good morning.
All right. Good morning.
Your Honor, I have just one case on the 9 o'clock docket. Randy Gould, Gould, 20 CT 151.
Okay.
Your Honor, this is a motion to terminate probation. Mr. Gould, pursuant to the agreement in the court sentence, he was sentenced to 12 months county probation, which he was serving on mail-in with the ability to petition the court after 9 months. There was an amended charge down from an elevated DUI to a simple DUI. He has passed the 9-month mark. My understanding from his probation officer is that he's been in compliance. So I hope that, sounds like Ms. Torres is in the courtroom. I hope she confirms that as well. My ears are still somewhat good. I thought I could hear her voice. So,
good. Your ears are good.
Assuming she confirms that, I would request that his probation be terminated.
All right. State any objection.
As long as he's completed his conditions, we would have no objection.
Your probation has to be heard. Very good. The motion is granted. Mr. Hopkins, will give me an order, or I can just do one.
I'll submit an order, Your Honor.
Okay, very good. Thank you, sir.
All right, thank you. Have a good day.
You too.
You too.
All right, Ms. Woodley, does your client still wish to go forward with the plea?
No, Your Honor. So for case for 9, we can put it for a plea trial. We would like another for trial.
Okay. All right, very well. Ms. Santini, I don't know if you could hear that. Mr. Surya has changed his mind. He wished to put this case towards a trial. Is that correct, sir? You wish to reject the state's plea offer at this time and we'll move this case towards a trial? Very well. All right.
Is this case in trial posture?
No, I'm putting it on a pretrial.
Okay.
And we'll go to trial from there.
Okay. What date is that, Your Honor?
That's going to be, well, I've got a pretrial. Let me ask you this. I've got a pretrial on Thursday. Will the state have witness availability at that time? Just at least knowledge of witness availability.
Yes, Your Honor, we can have that ready. That's for this Thursday?
Yes. So I've got a pretrial on Thursday. Sir, you're not going to be required to be present on that date and time. And then if the state is ready, once you have your witness availability, on the 4th, if the state's ready at that time, we can put on the trial call on the 22nd. If not, we'll roll it for.
Because I believe that the trial will probably be on the 24th, essentially.
Yes. Well,
What's the later, it's the next trial date?
April.
April 5th.
The next pretrial, I've got the 4th, and I've got the 8th.
Could we do the April trial date instead?
State, do you have an objection with me putting this on the 8th instead of the 4th?
April 8th?
Yeah.
No objection.
Okay, that's fine. We'll set it for pretrial April 8th at 9 o'clock. Sir, you're not required to be present at that time. You're welcome to be present. You can join in on Zoom, but you're not required to be. But you do need to stay in touch with Ms. Woodley because from there, we're likely going to be setting it for trial. So you need to be ready to do that, okay? All right. Please sign for your notice, all right? Yes, ma'am. I'm seeing you at 3. I'm seeing you at 3 o'clock for a motion. Is that right?
Yes, I will be able to.
Sounds good. All right. Thank you. Yes, ma'am. Thanks, sir. All right. Do I have anything else on the 9 o'clock? So,
Your Honor, we have a motion for medical records for Medardo Soto Garcia, 21 MS 31.
sorry, that's
And he's pro se.
8:45. Got it. All right. All right. 21 MS 31. State of Florida versus Medardo Soto Garcia. This is the state's motion for subpoena for medical records. And the notice was sent. Were Zoom codes ever sent out to the defendant?
Yes, Your Honor, it was sent out on February 11th, and it was sent to his address at 1046 Garden Lake Circle.
Okay. So what's been filed is just the notice of hearing, but it does, the notice of hearing does not have Zoom codes on it, so there's a separate mailing with Zoom codes.
I'm sorry, it was hard to hear. You said something about Zoom code?
Right.
No, yeah, we were just assuming he would come to the court and not be on Zoom. And people are allowed into the courtroom, so we just.
They are. All right. And did you get any return from the notice?
Not. I can look at Showcase real quick, but oh, never mind. So no, we have not, Your Honor.
Okay. All right. Then we can proceed.
Okay. So in case 21 MS 31, you're just requesting for the court to grant the state's motion to subpoena the defendant's medical records from Collier EMS and Naples Community Hospital North from the date of January 24th, 2021 until date of discharge. As Your Honor is well aware, the standard is relevancy. The defendant's being investigated for a DUI damage charge, and he has exhibited signs of impairment. He was taken to the hospital, and so we're asking that the court grant the state's motion to subpoena the medical records.
I reviewed the state's motion. I reviewed the probable cause affidavit that was attached to the state's motion. It includes the fact that medical blood was taken and had a BAC of 0.387. Therefore, the state's motion is granted. And you can get me a proposed order.
Yes, Your Honor, would you like me to print it in the courtroom or email it to you? Oh, never
I
mind.
think we have a state's printer in this one. This is the civil courtroom. So if you can send it to Sarah, please.
Sarah? Okay, I will.
All right, thank you.
Thank you.
Thanks, sir. All right. See, we've got Mr. O'Brien has two things at 9, but he also has an 11 o'clock. I think his intention is to deal with those at 11. Let's see. Will the computer let me do the plea?
So I have to call my ass. I try to even searching for words to try to fix it myself, and I can't solve it.
Yes, please.
I'm gonna have to call my ass to do it.
All right. And I think that's otherwise it for the 9 o'clock.
Yes, Your Honor. Do I need to wait for the PIA for
You don't.
the Mendez?
No, you don't have to. I'll make it go through whenever we can. So,
Okay.
and I don't think we have anything at the 10 o'clock.
No, Your Honor. But I'll see you at 11.
At 11. Yes, ma'am. Thank you.
Okay, is it going to be in 4-2 as well?
Is this going to be in 4D?
4D.
With that, there was a question. Mr. O'Brien thought that it was going to be virtual. I was under the impression it was going to be in person because I thought you had a live witness and video and all that. I don't know if that was ever settled. So I'll log in on Zoom. But I thought for an evidentiary hearing, we were going to be doing that in person. I don't know what his plan is.
Yeah, I didn't hear back from him, but I did let Sarah know that we'd be there in person.
Okay, sounds good. See you.